Start. All the five defendants have filed a joint written statement, wherein they have denied the plaintiff allegations of the defendant having caused death of deceased. Stop. They have stated that the charge of murder was not proved and the defendants were falsely convicted for having caused hurt to the deceased. Stop. They have denied that they had any enmity or malice to the deceased and have further pleaded that as the first defendant was the leader of the village, the first plaintiff, under the false guidance of the enemies of the defendants, has falsely accused them of murder and thus caused them harassment and pain. Stop. The defendants have denied that the plaintiffs or the two other beneficiaries have suffered any damages or were entitled to any damages. Stop. Their plea is that there was no special alteration in the first plaintiff's earning capacity or in the means of earning. Stop. Para. On consideration of the oral and documentary evidence, that was on the record before him, the learned trial judge reached a finding that the plaintiffs had failed to prove the facts alleged by them in the plaint and therefore, negatived the first issue. Stop. On the second issue, the judge held that in view of his finding on first issue, he did not consider it necessary to decide the second issue. Stop. He, accordingly, dismissed the VAT on his finding that the plaintiffs had failed to prove the plaintiff allegations. Stop. Being aggrieved by the aforesaid judgment and decree of dismissal of the suit, the original plaintiffs have filed this first appeal against the original defendants and this has now come up for bearing before us. Stop. Para. Learned advocate appearing for the appellants has contended that the learned trial judge was in error in finding that the plaintiffs had failed to prove the plaintiff allegations relating to the death of the deceased. Stop. He also contended that there was sufficient evidence on record to reach a conclusion that the defendants had, by their wrongful acts, caused fatal injuries to the deceased, as a result of which, he died instantaneously. Stop. He further contended that the learned judge was in error in not deciding the second issue, even though, the parties had joined the issue and led evidence on the question of damages. Stop. Para. Before discussing the aforesaid contentions, we may say that although the first issue is broad-based as aforesaid and has relation to the defendants having caused murder, stop, the parties, as appears from the pleadings and evidence on the record, have understood the plaintiff allegations as relating to the defendants having, by their wrongful acts amounting to crime, caused death of deceased. Stop. Therefore, for our purpose, we will consider that the parties have joined issue on the pleadings aforesaid and the first issue so framed, though broad-based, covers the issue of alleged wrongful acts of the defendants, resulting in the death of the deceased. Stop. Para. Before we discuss the material evidence relating to the alleged wrongful acts of the defendants resulting in the death of the deceased, it will be convenient to first set out the topography of the place of incident, the relationship of the defendants inter se and certain other facts as they emerge from the evidence on record. Stop. Para, it is disclosed from the evidence and is not disputed that the deceased Shana, along with his wife and four minor children, was living in a hut situated in a field. Stop. This hut had no door as stated by the first plaintiff. Stop. It also appears from the evidence of first plaintiff that deceased was cultivating about 5 bighas of the aforesaid field. Stop. These facts are not in dispute. Stop.